Hello friends, please like, subscribe, share and comment. It will motivate us to carry on this project for the welfare of students preparing to get government job through shorthand. Thank you for watching. Ready, start. Learned counsel for the petitioner submitted that the dispute whether a charitable trust is a public trust or private trust involves civil dispute like that of determination of title and therefore cannot be decided by the authorities under rent statute. The court of small cause is also one of such authority, hence it is barred, and the impugned judgments therefore are wholly without jurisdiction. In my view, the submission is thoroughly misconceived. There are two types of authorities before whom proceedings under rent statute, that is Act 1972, can be initiated. The first executive authorities, that is the district magistrate or an officer authorized by him as defined in section 3C. The second, a prescribed authority, which means a civil judicial officer or judicial magistrate authorized by district judge to exercise, perform or discharge all or any of power and functions or duties of prescribed authority under the act. Besides, two, there is a third forum where a dispute relating to landlord and tenant can be taken by filing a suit, and that is the court. There are certain provisions which obliges executive authorities, that is the district magistrate or any officer authorized by him, to ensure implementation and observance of Act 1972. The provisions like Section 21 bring in a judicial officer as prescribed authority to entertain a dispute and adjudicate the same. Then there are provisions under Act 1972 which have conferred appellate oblique revisional power upon courts, that is the district judge or any additional district judge authorized by him. Here the orders, whether passed by executive authorities or judicial authorities like the prescribed authority, are subject to review. The relevant provisions in this respect are sections 10, 18 and 22. These are the forums referred to specifically by Act 1972 for the purpose of procedure. Section 34 read with Rule 22 of UP Urban Buildings Regulation of Letting, Rent and Eviction Rules 1972, hereinafter referred to as the Rules 1972, import certain provisions of Code of Civil Procedure applicable to all the above authorities, that is the district magistrate or prescribed authority or appellate authority or revisional authority. It goes without saying, while these authorities would be exercising powers under Act 1972, they would have to follow the provisions of Act 1972 and the procedure prescribed therein meticulously and rigorously. To that extent, Act 1972 has been given overriding effect over Code of Civil Procedure, White Section 38 of Act 1972. A civil suit in certain respect is not completely ousted, but to some extent it is restricted by Act 1972. Section 20 permits filing of suit in certain matters, provided certain conditions and grounds existed are satisfied. A suit can be filed in appropriate court provided conditions mentioned in section 20 are satisfied. Thereupon, for the purpose of procedure, etc., the court would be governed by common law, that is the procedural statute. Then the issue here would be what a court or civil court means. The term civil courts and classes of such courts is found in Bengal, Agra, and Assam Civil Courts Act 1887, hereinafter referred to as the Civil Courts Act 1887. Section 3 thereof talks of classes of civil courts as under. The Court of Small Causes are established White Section 5 of SSC Act 1887. By Section 15 thereof, all suits of civil nature are cognizable by it, except as specified in second schedule or exceeding pecuniary limit provided in subsections 2 and 3 of section 15. A judge of small cause court by virtue of section 13(4) is also a subordinate judge or munsif within the meaning of section 13. Stop.